Peace and love is your boy. It's a man. I think it's my school by El Bay. Doing my thing here. Spreading the truth and the light in the best ways. Instead of just studying and reading by myself, I thought, hey, why not record it? So in case I'm walking, I want to go over some notes or something, I could just replay it on my phone. And I'm thinking, this will share with other people that might be studying the same thing or not. So I'll just put it out there and share it with the world. So we are talking about the United States Supreme Court, the Constitution, and the common law. Do you know your rights? What corrupt politicians and lawyers don't want you to know about traffic courts. Dun, dun, dun. Do you know about color of law? Google that right now. Color of law. Also Google colorable law. So, do you know about color of law and racketeering practices amongst city and town politicians by their quasi-criminal traffic courts to deprive the people of their rights and their property? Do you know the difference between a right and a licensed privilege? Have you witnessed unlawful profiling in your community? I'm sure you have. We all have. Go to facebook.com/VM Enterprises. Go there. You will find some awesome videos, and also you'll find links to the YouTube where you can see some solutions. So, have you witnessed unlawful profiling in your community, as I just said? And the Supreme Court of the United States of America has addressed the substantive law dealing with the substantive rights of the people. And if we are not aware of these rights, sharpen whatever traffic in these cases and what they mean to us, because when a case makes it to the Supreme Court, the rest of the courts have to abide by that. So when they take you to court, per se, in your county or this or that, in a Supreme Court case that deals with the same thing, it's already been decided on. That judge has no jurisdiction over you to begin with because you're a Moor, it's if you realize that you're the natural person and you have rights to the land and everything like that, you won't really have to deal with them in the same way because they don't have rights. And you gotta start asking for their bond numbers and their names and everything like that, and the 1099 OID number, or questioning their jurisdiction. But as a magistrate, judge, or whatnot, appointed agent, you know, then it really won't. There's so many solutions. It's just about which one you want to pick. But if you're not aware that you have to, figure out your nationality and make sure you're a secure party, then it's really important to do that. You got to get your trust game on. And here we go into some of these cases, son. Let's read through these real quick. There's 13 cases. Dun, dun, dun. No, let me stop. Shout out to one of these sponsors, Chorus Forest. These speakers that they make, you put your tablet on it. It's pretty cool. Check it out. I know a lot of people are gonna. Oh yeah, shout out to Guns Down, Life Up people. They make shirts. I guess they sell them. Shout out to the iHorse and Moorish American flag. Shout out to Al Marak and this land we stand on, and all the people that have, been doing what they can to lay down a path for us to go to that will make it easier in this land and life and everything like that. So here we are. The right to travel, the right to mode of conveyance, the right to locomotion are all absolute rights, and the police cannot make void the exercise of rights. State versus Armstead, 60 S 778, 779, and 781. The use of highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and natural beings cannot be deprived of our right to travel. Chicago Motor Codes for Chicago, 337 Illinois 200, 169 North NE 22, ALR. Lagar vs. Chicago, 139 Illinois 4628 HE 934. Boone versus Clark. 214 SW 607 28 AM JUR First Highways SCC 163. The right to travel or park is part of the liberty of which the natural person, citizen, cannot be deprived without due process of law under the Fifth Amendment of the United States Constitution. Kent versus Duels, 357 U.S. 116 125. So if you're a natural person or a citizen, which Negro, Black, Ethiopian, African American are 14th Amendment uh, legal fictions. So this is clearly why they be taking our right to travel and park all the time, yo. Because we're not protected under this Fifth Amendment. Wow. If you consider yourself Black, Negro, that is nuts. Anyway, let's move forward. The right, okay, the right of a citizen to travel upon the public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege which a city may prohibit or permit at will, but a common right which she has under the right to life, liberty, and the pursuit of happiness. Thompson v. Smith, 154 SC 579. State police power extends only to immediate threats to public safety, health, welfare, etc. Michigan v. Duke, 266 U.S. 476 LED at 449, which driving and speeding are not. So state police power extends only to immediate threats to public safety, health, welfare, etc., which driving and public safety are not. California versus Farley, SCD, RPT 8920, CA 3D 1032, 971. So, as I'm saying here, it's pretty substantial. Something how if you don't know about law like that, you know what I'm saying? Like how would you know that about these shits? Like it's crazy because like here, let me just send somebody the link to the show. So if you want to send somebody a link to the show, this is the am I talking like a cartoon again? Sorry, it's this thing I do. Forgive me. It's like nah. Anyway, the link to the show is ustre.am/1 lowercase b uppercase u 7 uppercase c. Okay, I know that was confusing, but anyway, replay that to hear it. And also to the other channel on Omnipresence Media where we have some shows. That is ustre.am/3 lowercase y uppercase vt. And there you will find some amazing shows. No, too much? Okay, my bad, sorry. Anyway, here we are. Continuing with the woo. Okay, anyway. The state is prohibited from violating substantive rights. Owens vs. City, 445 U.S. 662, 1980. And it cannot do by one power Example, police power, that which is, for example, prohibited expressly to any other such power. Expressly to any other such power. As a matter of law. Example, taxation, eminent domain. U.S. and UT versus Daniels 22p 159. Nor indirectly that which is prohibited to it directly. Fairbanks versus U.S. 181, U.S. 283, 294, 300. Yeah, not good to do that on there. Yeah, seriously though, this is like real like Supreme Court cases. Like these more people went to like cases for probably days, weeks, maybe even months for these things I'm reading now for it to be, because when you look at, I'm glad I could say this and kind of what I'm talking about. When you want to understand law and what will happen in a court case, there's like three tiers I heard. This Black's Law Dictionary, when you're checking out the actual definitions, like when I said earlier to check the definition of color of law or colorable law, you don't want to go to any regular dictionary. You want to go to the Black's Law Dictionary. Like I'm a salesman for this bitch. Preferably the fourth edition. Fourth edition. Um, because every year they change it to make the words different meanings and more confusing. So that's what that is. But like I'm saying, when one of the first tiers is actually the cases, what happened on them. So the results, the judgment, and what I'm reading to you are judgments from cases about citizens and natural persons' rights. So let's go back into this. Okay. So again, the state is prohibited from violating substantive rights. Owens v. City, 445 U.S. 662, 1980, and it cannot do by one power, example, police power, which is, for example, prohibited expressly to any other such power, example, taxations, eminent domain as a matter of law. U.S. and UT v. Daniels 22p 159, nor indirectly that which is prohibited to it directly. Fairbanks vs. U.S. 181, U.S. 283, 294, and 300. Excuse me. I got this at the what's it called? 30th anniversary for G-Shock. You think this is dope, man? I fucking these are just material possessions. Our body is way more cooler. You know. So anyway. Traveling in an automobile traveling in an automobile on the public roads was not a threat to the public safety or health and constituted no hazard to the public, and such a traveler owed nothing more than due care as regards to tort for negligence to the public, and the owner owed no other duty to the public, he, she, and his/her auto having equal rights to and on the roadways, highways as horses and wagons, etc. This same right is still substantive rule in that speeding, running stop signs, traveling without licenses, plates, or registration are not threats to public safety, and thus are not arrestable offenses. Christie vs. Elliott, 216 I 131 74 HE 1035 LRA NS 1905 to 1910 California vs. Farley 98 CED RPT 89 20 CA 3D 1032 1971. Under the United States Republic constitutional system of government and upon the individuality and intelligence of the citizen, the state does not claim to control one's conduct to others, leaving one the sole judge as to all that affects oneself. What? Let's read this again slowly. I'm studying here, so. Under the United States Republic's constitutional system of government and upon the individuality and intelligence of the citizen, the state does not claim to control one's conduct to others, leaving one the sole judge as to all that affects oneself. Mugler vs. Kansas, 123 U.S. 623 639 60. If I'm not mistaken, does this mean that if you're have intelligence and individuality, you can do whatever you want based on judging yourself to what balances you, because you wouldn't even be able to get to that state of control and mind in a way that's good to the community and not be in trouble all the time. That is nuts, son. Maybe I'm just reading into this too much. Is it just me, or did this, anyway? Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Oh, I read that before and missed it before. The one before I just read. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Randa vs. Arizona, 384 U.S. 439, 125. The claim and exercise of the constitutional rights cannot be converted into a crime. Miller vs. Kansas, 230 F. 2 second, 486-49. So when they're like you're driving and you run a stop sign and they turn that into a crime because you're not even a citizen or a natural person if you check black, American, African American, Ethiopian. This is all 14th Amendment legal fictions. That's why a lot of people are getting, what? It cannot be this simple, yo. So anyway, for a crime to exist, there must be an injured party, corpus delicti. So, like, if a corporation sues you, okay, who's the injured party? Because a corporation is a legal fiction. How can they, because according to this, there can be no sanction or penalty imposed on one because of this constitutional right. Scherer vs. Cullen, 481 F. 945. If any tribunal court finds absence of proof of jurisdiction over a person and subject matter, the case must be dismissed. What? Yo, so Judge Joe Brown, I heard, was saying that the judge, because he got arrested over the weekend or not the weekend, in child custody court or something. He was representing some woman or whatever, and I heard he got 5 counts and arrested because he was saying that the judge didn't have jurisdiction over the case. Like, a judge saying that, like, that shit is crazy. He must know something. Anyway, for a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of this constitutional right. Scherer vs. Cullen, 481 F. 945. If any tribunal court finds absence of proof of jurisdiction over a person and subject matter, the case must be dismissed. Louisville vs. Motley, 2111 U.S. 149, 29 S. CT 42. The accuser bears the burden of proof beyond a reasonable doubt. Lack of federal jurisdiction cannot be waived or overcome by agreement of parties. Lack of federal jurisdiction cannot be waived or overcome by agreement of parties. Griffin vs. Matthews, 310 F. Supra 341 342, 1969. And want of jurisdiction may not be cured by consent of parties. And Industrial Edition Association VSIR 323 US 313. Anyways, woo! That was mind-boggling. 13 cases at least that say a lot of stuff. United States Supreme Court, North America, Article 3, Section 1 of the Constitution. For the United States of America, Republic, vested judicial powers and establishment of inferior courts. Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Whereas there is no question that a bench summons, a detention and arrest, a ticket or a citation issued by police officers or by others for parking or traveling with no driver's license, a foreign driver's license, or no current registration, or no mandatory insurance, which carries a fine or jail time, is a penalty or sanction, which is indeed converting a right into a crime, thus violates substantive rights. It is reasonable to assume that the court's judicial decisions are straight and to the point, and there is no lawful method for government to put restrictions or limitations on rights belonging to the people. The right to own and to possess private property and personality and to be secure in those rights is preserved and secured for the people and the citizens by the Constitution. Government does not give rights, for it has no rights to give or to sell, nor to license. Government is put in place to protect and to secure the pre-existing inalienable rights of the people and the citizens. So this government is supposed to be enforcing the Constitution and the people we elect as a republic, but it's a democracy, demonocracy. So that is nuts. Just keep reading because this is hitting me. United States Constitution Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Article VI, Clause 2 and 3 of the United States Constitution. Clause 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or the laws of any state to the contrary notwithstanding. Clause 3. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification by any office or public trust under the United States. So you can check out the official Moorish and Heritage history classes every Wednesday, 6 p.m. to 10 p.m. at the National Black Theater, 125th Street, 5th, Harlem, New York. Check out rbbaypublications.com. And thank you guys so much for listening. Peace. It's your boy, Vickens Moscova. El Busy Easy.